So back at page 10 of this, you talk a little smack about summer 2004 me. So I'm said to be too casual. Okay, so I'm taking a break from my dissertation, and I'm writing this article about the implications of Frege, Gottlob Frege, for constitutional interpretation. And, where is this?
By the way.
Too casual. Let me find the page number of this. Okay, page 9. Okay, not page 10. So I'm 30 pages into my article. Okay. May come as a surprise for some time, the originals have actually been endorsing this questionable consequence of their method of looking at meaning rather than tangible applications. Although they describe it in a different way, they remind us that parties to a contract, for example, cannot possibly anticipate all permutations of its meaning. Footnote 65, C, for example, my article, no pin site. Public meaning originalists often apply this point quite casually, as if it were widely accepted in a constitutional law context and had no adverse implications. Footnote 66, see id at 580 to 82, but 30 pages into the article. Okay, so it strikes me that, why do I think that there's a distinction between sense and reference? It's based on the philosophy in the first 30 pages of the article, okay? It's not because I think it's our thought 16 years ago that it was widely accepted in constitutional law theories. There's a way language works. There are people who think about how language works. It doesn't matter how much history you do. Historians are not the one to tell you whether there's a good distinction between sense and reference, okay? So I'm imagining somebody discovering quantum mechanics in the 1920s and saying, dude, are you aware you're taking quite casually the implications of quantum mechanics for the destruction of cities? So the next sentence, okay. So as I will argue, however, this move has the potential to blow the whole works, so to speak. So I'm imagining, Heisenberg, it's 1925. Do you understand that the thing you're saying about how reality works has the potential to blow the whole works? And he's like, what? I am trying to understand how physics works, okay? So 2004 me says, what? I'm trying to understand how language works. Frege was right. Quine was wrong, okay? Now, one response to that is, I think Quine was right, okay? If you think Quine is right, you're taking sides in a philosophical debate. You can't just cite historians. Okay, so you have to get into the historical materials with a properly philosophically framed question in mind. You can't just say, I want to blur sense and reference because of history. I mean, that's just, that's not how it works. Okay, it shouldn't be how it works. But that's what Raoul Berger says in 1982 in response to Hugo and Hazel. He says, well, for the framers, they blurred sense and reference. I'm like, that doesn't make Quine right. Okay. Civil, social, political, the judge mentioned, I mean, just relying on a book. There's a whole bunch of material. That's 2004 me, then there's 2015 me. Appendix F of my book, there's a whole bunch of material just saying, the Democrats were just right. Education segregation is a social right. The Republicans disagreed, and I think they were right, and I see no reason to think. I should have looked at her book, I suppose, but there's an awful lot of evidence that the Republicans were right in 1872. In terms of, does the conclusion that women lack the right to become lawyers depend on the facts? Well, Bradley certainly thought so in 1872. That's why he wrote his concurrence in Bradwell the way he did. Finally, originalists don't have any explanation for what happened in 1875 and 1876 about the fall of Reconstruction. Well, they're interpreting the Constitution. They're not interpreting like American history. It's like saying originalists don't have any view about what to do about the designated hitter rule. I mean, it's just it's a different thing. So the way I see it, Martin Luther King had the right basic picture. He says, we have come here to cash a check. It's a check that has come back marked insufficient funds. What's originalism trying to do? Trying to figure out, what does the check say? What did it mean in its original context? Okay, so if you're trying to interpret the check, you've got to do it according to the text and the original context. Why has that check come back marked insufficient funds? Well, it's because post-bellum situations are very difficult, and Grant really wanted Hayes to win the governor's election in 1875, and J.Z. George, Lucius Q.C. Lamar, that stuff, 1875. But that's not the Constitution. That's the Constitution coming back marked insufficient funds. So to say, like, well, I mean, imagine I got a blank saying, well, of course it came back marked insufficient funds. Didn't you interpret me when I said there was insufficient funds? Well, that's not what the check said. The check was written during at the beginning of Reconstruction. Okay, so that's why originalists look at that. Anyway, that's my fourth point. So a final blast to keep everybody awake. So that's my value add.
I think optimistic originalism is just a version of optimistic interpretation, which all of us do. All Americans interpret the Constitution optimistically, and they do that because we revere the Constitution as an anthropological matter, and that hasn't always been the case, but it's true of modern American constitutional interpretation. I'm reminded of my favorite, and the only Dworkin quote I actually like, my favorite Dworkin quote, which is the alternative to happy endings is unhappy endings, and like, who wants unhappy endings, right? So my question is whether there is anything interesting that one can say about optimistic originalism as opposed to optimistic pluralism or optimistic non-originalism or living constitutionalism or whatever one wants to call it. And I can think of a few possibilities. One is we should appreciate optimistic originalism because we can derive something interesting from it, right? So optimistic living constitutionalism doesn't tell us anything because there's no real alternative to it. Whereas optimistic originalism, we have some criteria for criticism of that. We can say, well, you're optimistic, but here's the evidence. And so there's some criteria you can use, and that's useful for accountability of judges. The second thing cuts in the other direction, though, which is to say the presence of optimistic originalism, if there's nothing else, is a very bad verdict on how originalism has succeeded as a methodology, if you're right about that it's ubiquitous. And the third thing is something you allude to in the paper that I think is actually quite important if we're trying to sort of get at what we think about these practices, which is that the heroes of optimistic originalism are judges, which is to say they're people who are interpreting the Constitution in a way that allows it to play a good role or to be a good thing. Whereas the heroes of optimistic non-originalism are social and political actors, and that might be really important for how we think about our own agency within constitutional law. So I'm just inviting observations about that.
Thanks for the paper. I want to raise the possibility that there's originalist scholarship out there that has actually tackled this or grabbed this bull by the horn, I guess, this self-government, localism, federalism that you seem to suggest is overlooked in the literature. Specifically, you say things like public education and public accommodation, or education and public accommodations were seen as the proper preserve of the state governments, right? They cared about local control and federalism, and therefore it doesn't make sense to say that there would have been federal power in these quote, areas traditionally reserved to the states. You say that in your paper. But of course, the matters at issue in the black codes were traditionally reserved to the states. Contract rights, property rights, the right to sue and testify, the right to own a firearm for self-preservation, these were all traditionally reserved to the states. But the whole point of the 1866 Civil Rights Act and the Privileges or Immunities Clause, I think, was at a minimum to invalidate the Black Codes. And so I guess my question is, doesn't the anti-discrimination reading of the Privileges or Immunities Clause, propounded by David Curry, Chris Green, and John Harrison in this room, and I guess I'll say now, it's going to be the argument in a book that I have forthcoming in the fall, doesn't that approach to the Privileges or Immunities Clause actually satisfy all of these concerns about federalism and local control? The states define the contents of all these rights. They define contract rights, they define property rights, they define education rights. What they can't do is discriminate in the provision of those rights once they've defined the content of them. They can't give whites more rights to these things than to blacks. And I think that was William Nelson's point too in his book in 1988. So isn't there much scholarship in originalism that comports with all of those historical things you're concerned about?
Well, I'll take that last one first. That's exactly right. That was one of Nelson's points, that the best answer to some of the objections to the 14th Amendment was the state-based equality theory. I'm not sure what is the right rubric, but the privileges or immunities theory. That was one of Nelson's points, but another one of Nelson's points was it wasn't a settled matter that was the theory. You could say, look, Steve, in the present, we've got this theory of privileges or immunities, well grounded in history, and it solves a bunch of problems in the present. That doesn't mean it's accurate to say that in the past they chose that theory. That's what I'm operating on. And they might have solved some problems for themselves had they stuck to it. Well, that's what Nelson says. But something Nelson always emphasized was making sure you were asking questions of history that history can answer. And he didn't think history answered the question of whether they actually settled on that theory, as opposed to like the theories that Randy Barnett likes. There's an alternative approach, and there was alternative approaches back then. It could well have confused judges because they didn't give judges any help. So to Chris, perhaps we need a longer conversation. I certainly should have cited other people who make the same point you do. I didn't just have you in mind. But there could be all kinds of absolutely valid philosophical distinctions out there that, when applied to constitutional law and when applied also, in a more normative vein, have counterintuitive implications. And I don't just, cite you there. I developed this later on in terms of the DC evidence. So I have a little more in the paper about your article than you say. But I don't view it as, taken for granted that any valid philosophical distinction will have necessarily a decisive effect in constitutional law. To me, I've lived through too many debates where philosophers and others thought that, they'd solve a lot of constitutional problems by propounding distinctions. It never seems to quite work out. But the other thing that's very important is, you recur just right now to a viewpoint that I'm very much against, and that is all of the bad side of Reconstruction, all of the failure. Well, that's just political. No. There is substantial evidence, and that's why I go through it in part 2, that the Republicans are conflicted. Nearly all of them are conflicted. Very few of them hold contemporary views on race or anything else. Only a few of them do. On specific issues like school desegregation, you can find more. But we've lost over time the sense, because of the influence of optimistic views, we've lost the sense that there were constitutional reasons for the failure of Reconstruction. Now, some of these fall away. They fall away even by the early 20th century, where the beneficiaries, and I talk about this, the NAACP lawyers are arguably the beneficiaries of some of the distinctions falling away. The civil, political, social doesn't make any sense anymore. But that is by itself evidence that a more living constitutionalist story is the righter approach. And then Jamal, look, at moments of change, it's not so obvious that you can just rest easy in the parkland of optimistic constitutionalism. Before the Civil War, I don't get the impression anyone was resting easy. They were involved in a fundamentally grinding debate in which every possible method of interpretation, every possible scrap of evidence was being seized on and torn over. And in that context, you can't say, well, we're all united by being optimistic. It's just as much a product of division. And if you're in that moment, you might be brought to realize, well, we're going to have to make a change, and we're going to have an amendment. Now, I'm overstating things for effect, but we've been living through a period, I think accurately described by Bruce Ackerman, as one in which we all think we don't need amendments anymore. We've gotten out of the habit of amendments. The kind of attitude you described, to me, is sort of like part of a massive conspiracy designed to convince us we don't need to do amendments anymore. I'm on the constitutional reform side. I'm more with Sandy. I'm more on Sandy's side than Jack's side, even though I can't convince myself a constitutional convention is a good idea. If you're operating from that perspective, whether before the Civil War or now, then the optimistic side of constitutionalism is more like taking a sleeping potion.
Recurring thing you say in the paper is that originalism can't really handle there being actual multiple public meetings. And I just don't think that's true if you have a conception for how to select the meaning that is the legally applicable meaning, and that ends up making your sequencing problem not a problem. So like, let's say there's something in the 13th Amendment. It could be, there are some people that think it means X and some people think it means not X. It turns out that X is the better interpretation, but some folks are getting some traction with this not X theory. And so then the 14th Amendment is passed that says it's definitely not X. That we're not doing that thing. It's entirely consistent with originalism to be able to recognize that debate happened, that the 14th Amendment was passed in light of that, and that the 13th Amendment might have a meaning that seems inconsistent with the belief that some people had when the 14th Amendment was passed. And that just doesn't seem in any way problematic. The second point that I think that I wanted to make is that the real meat of your paper is a little bit in the subtext, which is it sounds like you're extremely uncomfortable with when original expected applications deviate strongly from what someone claims the original meaning actually is. And an interesting argument that someone could make and would be that, the reality is that maybe you should be skeptical if you have too much of a difference, because in reality, definitions influence what examples we think apply, and examples we think apply influence our understanding of a definition, and it's more of a positive reinforcement mechanism than one being purely causal of the other. But, per Chris, in that whole discussion you just had, it's so common when, we've all presented papers where someone says, well, if you're right, doesn't that mean this thing is true? And you have to think about it, and you're like, maybe it is, but, and the time you're most likely to be wrong and say, no, it doesn't mean that, is when you have a kind of strong emotional commitment to that not being true. And that leads right into the comment on page 44 that you have about, it seems really implausible that people thought women were that incapable in the 1800s. I'm like, yes, they did. And that created a motivated reasoning to not see certain things that really conflicted with these deeply held beliefs about people's capability. So, but I think it would be really great to bring out more, because I think it is a real issue, the discomfort when we say the original meaning is very far from the original expected applications, because maybe that means we need to give a better explanation for why than we sometimes do.
That might be that either Will is not an originalist or you are, because I think, but as I read Will and Ryan, they're saying we ought to not allow textual clarity or semantic clarity to preclude consideration of what could be called communicative context, including purpose or structure, like their general ideas about federalism. Instead, we should evaluate these on a sliding scale. And so it might be that the text viewed in isolation is plain in one sense, but it departs radically from structure or federalism. It means we should take a second look, and we might demand a higher level of clarity in order to say that the text forecloses looking at purpose. And as I understand Will, and I'm just going to channel for him because I've appointed myself his counsel, this is perfectly consistent with originalism, even original public meaning, because it simply gets rid of an idea that doesn't really have much linguistic backing. I mean, Ryan Dorfler wrote another article which said, the philosophy of language nowhere says that semantic considerations should preclude or have lexical priority over purposive or, I'm going to use the word advisedly, pragmatic considerations. That is to say, all the context you mentioned, like their general ideas about federalism, what they generally were trying to accomplish. So maybe that'll solve all your problems, and you can all get together on this sliding scale, original public meaning idea.
I just want to give a friendly rejoinder to Chris, and I'm a big fan of his work, and I think the sense-reference distinction is an interesting way to think about constitutional law. But in light of what he said, I just want to go on record as saying there are a lot of problems with the Fregean picture of sense and reference as applied to natural language. There are many first-rate linguists and philosophers of language who think the picture that Frege provides is the wrong picture. It doesn't work well. Scott is here, and I'm sure he knows some of the people to whom I'm referring. So they prefer an intentionalist, non-referential conception of language, for example, and point out that even for the simplest terms of natural language, like proper names, London, what is the sense and reference of London? That turns out to be a really hard problem. So I just think it's a mistake to imply that that's a settled matter the way that the physics analogy might suggest. So I'll invite Chris to have a drink with me afterwards, and we can debate that. My question has to do with what you say on 32 and 33. This is really an amazing part of the paper for me, because you kind of spell out some of the implications of optimistic originalism for the federal consensus and the 13th, 14th, and 15th Amendments, and you sort of have this domino theory, like they're all going to start to become unnecessary on certain conceptions of optimistic originalism. And my reaction reading this was, well, why not? Depending on what your theory is of originalism, or your theory, I wish Randy were here because I was going to invoke some of his ideas. So suppose you think, as Randy does, that first come rights, then come government. And so we do have to understand the entire American governmental system through the lens of natural rights, including originalism in the original Constitution. And this is, I think, what many of the anti-slavery constitutionalists to whom you're referring had in mind. So I've been reading Jim Oakes's forthcoming book on this. He has this terrific account, as Randy did in his article about, whence comes Section 1. Why, at the end of the day, shouldn't we really take seriously the idea that public meaning originalism cannot model the antebellum federal consensus on slavery? I mean, there were people who thought differently than the federal consensus, and it's not clear to me why they're not entitled to have an originalist theory that departed from the dominant theory of the time. If you want to put this in Dworkinian terms, their theory of the Constitution in terms of fit and justification just led in a very different direction, because they leaned very heavily on the justification side. So they could read into the Fifth Amendment, say, anti-slavery implications, or they could say, look, of course all persons have a natural right not to be enslaved. Of course all persons have a natural right to equal protection of the laws. Well, if that's true, slavery falls, right? If simply the criminal laws and the tort laws and the other common laws were applied in any of the states prior to the Civil War, there would have been no slavery. And all we're saying is people have that natural right, and it's protected by the Constitution. For example, they could say Barron is wrongly decided and so forth. But my point is, once we start to think about optimistic originalism capaciously, it's not clear that your argument here really is compelling, because people could go very strongly in that direction and just have a different originalist conception of the Constitution that would be out of keeping with what the dominant majorities thought at the time, but is no less originalist for that and is, presumably justifiable.
The way I look at it, the conventional wisdom, the overwhelming majority of evidence is that Bradwell gets turned down for largely normative reasons that relate to the structure of the law. And that structure of the law is not altered in the opinion of the people who drafted it. So, but it's not on the basis of facts. I have a really hard time understanding Larry Solom's argument on that. I'm sorry he couldn't be here, but maybe you can clarify it for me, because the work that's been done over decades is well summarized by Laura Edwards, and I just don't see it as a primarily empirical matter, although of course there are complex relations between people's normative beliefs and empirical matters. And I guess that's what you're saying, but the normative side is pretty dominant, especially with all this evidence that the people in Congress know perfectly well that there are women of capability who are perfectly capable of practicing law. They just don't think it's a good idea. I will take the look at the scholarship that you talked about, and I'm sorry I didn't have a chance to get to everything. The sequencing argument, I don't see that I understand what you're saying, that you could have an argument and decide one side is better. My point is, when strictly followed, original meaning is leading you consistently to value arguments you shouldn't be valuing, that people at the time didn't value. So you're participating in constructing an alternate historical reality. And I'm kind of half serious when I say it has a Disney-like quality. We shouldn't be encouraging that. And that's also kind of what I think about the more extreme case of someone who rejects the federal consensus and follows an original meaning. That's Barnett's whole thing about Lysander Spooner. And could you take your constitutional law in a different direction by being super literal about the Constitution? This comes close to what I used to have in the paper. It made Randy really upset. I called it Civil War denialism. To me, someone like Spooner is in denial about the reality of the law around him. He doesn't even think the Constitution needs to be amended. I think we have to learn an important lesson there. It's not just a bunch of battles, and it's not just a bunch of politics. It's about a massive constitutional failure going on right in front of us. And that's also why I see that our history is discontinuous rather than continuous. It's massive evidence it was discontinuous, and that carefully developed arguments wouldn't solve that, because they didn't want to own up to the fact that they had to change their order, and that the resources they had, the argumentative resources they had, were inadequate to the task. That's also sort of my response on this idea of the promissory note. As far as I can tell, on the optimistic side, we all want to believe in that. But that's why I start talking about the challenges the NAACP lawyers faced in Part 4, which unfortunately I couldn't ask you to read. We have to take those challenges very seriously. If they had challenges, if they faced legal challenges, that would indicate that in order to cash the promissory note, we had to alter it. Had to alter it without saying so. And it looks ridiculous, right? It's a ridiculous position. Suppose you were an old line originalist telling Thurgood Marshall, well, I've assessed all the evidence, which some of the people on his side literally told him this. We've assessed all the evidence, and it doesn't look good. But if they were originalists, at least old-style originalists, like maybe Earl Maltz, who sort of delights in, sticking to bad results, let the chips fall where they may. They'd be telling him, well, it looks like we need another amendment there. Another amendment to accomplish what some people think, it's right, it's ridiculous, right? But it's a fact, it is a result of the Republicans, when they pass all this, not thinking through how much they have to change their own law. They compromise. I mean, there's a great example of this conceded by nearly everyone in the 15th Amendment. It's a compromise. They say that all the time. It's a compromise. They know how to compromise in a way that sets up tragedy in the future. Hard to say that the 15th Amendment, was like well planned, was a promissory note. We're still trying to cash that one. It's not there. That's why some people, a surprising array of people, are in favor of amendment national right to vote. That's been going on for decades. That's, there's some flaws there that you can't just cash out today.
So the paper talks about constitutional change. And it talks about different kinds of constitutional change. Formal, where we actually amend the text, and informal, where we do something other than amending the text. And it says that those channels of constitutional change can, in various ways and under certain circumstances, be either legitimate or illegitimate, which strikes me, I think, if I'm reading it right, as sort of a standard political morality analysis, so like ordinary normative analysis. But there's another set of distinctions that we often use when we're talking about constitutional change, which are very different. So we might talk about constitutional change in an internal or external way. Internal would be sort of internal to the legal story of where legal sources come from and how they work. And external is constitutional change on the ground, in practice, what's likely to happen to you if you walk down the street smoking marijuana, will you be arrested or no, et cetera. And there, we often talk about changes as being either valid or invalid. So you might have a change in constitutional practice that does not reflect change in the internal account of legal sources, and we might say that's invalid as an attempt to change the law. An example would be how we talk about statutory change. So you could talk about change of how the Sherman Antitrust Act is applied in practice, and Lord knows that's changed. But how often has the statute changed? Well, not as many times if what you're asking is how often has it been amended. You can have informal, internal constitutional or statutory changes. For instance, if they were in a jurisdiction with a doctrine of desuetude, it would be possible to say, oh yeah, that section was never amended, but it's just no longer in effect. Because we have, even as an internal account of what's in our legal system, we just don't use that section anymore because it's become desuet. Like you could have such a system, we happen not to have one here. And I think that a lot of the confusions that the article is pointing out, in fact, are cases where we're using constitutional change in one way or another way, and we're not tracking which kind of change we're talking about. So if someone says, the 14th Amendment provides exactly the same rights now as it did at the time of enactment, they are not making an external claim about practice and what's likely to happen to you. But they might be making an internal claim based on a theory of what kind of things are sources of our law.
Dave?
3 points very, very favorable to your piece, which was provocative and is requires me to change something I was working on. The first is I just want to mention this. Any of you ever going to want to look into the evidence of the states that Michael said he didn't have time to look at? The brief in Davis versus County School Board, one of them in 1953. It's an extremely extensive multi-state survey of things that are said and done at the state level. And anyone who wants to make an originalist case for Brown I think has to address some of this stuff. I think actually, I think it can be addressed, but it's pretty good. What the segregationists offered there. For the first time, I think ever, I strongly disagree with Chris and Christine and with you on the question of the facts of sex discrimination. Myra Bradwell's qualifications were unquestioned, and that was the assumed fact upon which the whole litigation occurred. Kansas and Wisconsin, the same year, the same session that's ratifying the 14th Amendment, propose and majorities vote for women's suffrage. They're not incapable of thinking of these things. In fact, I go further. If they were a bunch of blockheads and they thought women couldn't read contracts law books, they were so stupid we shouldn't be governed by their amendment. So in this respect, I would ask that maybe you distinguish that one particular article you're criticizing there from Michael McConnell's, because I really think it's a completely different order of just historical mistake and radical sort of original meaningism that's not consistent with original understanding, let alone, I think, historical fact. And lastly, I wanted to just suggest that you refine that Part 4 to make it more challenging to originalists. Because what I took from that, you could say, well, originalists can't explain the political failures. Originalists can't explain that would be one. Another would be the originalists can't explain the failure to give sufficient powers. But that's not an originalist problem. That's just saying, well, we understand the 14th Amendment. It just didn't give the right power. They didn't rehabilitate 15th. But the third would be originalists have to give an account, if there was an original meaning, why it fell apart so fast, why Slaughterhouse happened, And I take that as that's provoked me a great deal. And I think that's something that has to be addressed by 14th Amendment historians.
What's the difference between the informal constitution and the rest of the legal system such that there's a difference between informal constitutional change and, for example, the enactment of enforcement legislation, the repeal of enforcement legislation, the enactment of new enforcement legislation?
That last question went by too fast. I'm sorry.
What's the difference between the informal constitution? There's the written formal constitution, informal constitution, rest of the legal system. Because you talk about not understanding the importance of informal constitutional change. Well, to know what informal constitutional change is, you need to know what the informal constitution is and when it's changing. So how can you tell that some change is a change to the informal constitution as opposed to a change to other parts of the legal system that aren't part of the informal constitution? Why is the expansion of federal administrative capacity, if it is an informal constitutional change, as opposed to just the expansion of federal administrative capacity?
I do have a theory on this. It's constitutional change is state building. So, you're looking at a informal constitutional change, whether legitimate, illegitimate, valid, or invalid, when it's been institutionalized. It can be proposed, it can be discussed, but when it's institutionalized and is able to then to reproduce itself going forward. Now, why is that constitutional? Okay, that depends on how you construe the original formal baseline. Some further developments are simply articulations of what the framers designed. But when when I said at the beginning, I think we have to keep our books straight. That's meaning I think we have to define their design at the most specific level possible. Otherwise, we're liable to, first of all, fool ourselves as to what's going on later on. But also, we're liable to miss, because of our optimism, we're liable to miss points where we're actually deviating, we're actually changing things. So in these debates on, whether I've written a book on presidential war powers. That's a deviation. It wasn't really caused by evil living constitutionalists. As I suggest in the paper, these changes arise out of necessity. And then you tell whether they're instantiated or not by whether they're institutionalized. Anyway, that's my rough answer. I really appreciate, David, that you thought what I had to say on Slaughterhouse was useful, because I was really nervous about that, given the enormous amount of negativity toward Miller's opinion. I think Les Benedict's article has been overlooked to a certain extent, but I didn't want to take on defending Miller's reasoning. It's just that especially when you live in New Orleans and drink occasionally out of the Mississippi, you have reason to think that that wasn't ever going to be a case that was going to produce some kind of major change in the law. And I certainly favor the scholarship that's been going on, saying, for example, it didn't really foreclose incorporation. That's the way it looks to me. I didn't want to repeat those. And I'm sorry, Steve, your comments were just too general for me to follow.
You said that you think the history is discontinuous, but I find it very, very hard to fathom what happened to the country between 1876 and 1954. If that was the same country as in 1866, then the original public meaning that would embrace desegregation and equal gender rights, that would not have been ratified. You need a public meaning that's capacious enough to sucker people in, maybe is that the right, rather than a cram job, a con job, and I just find that narrative very, very difficult to believe, that there was this magic moment that lasted for just a few years. Bingo, got the constitutional language in, then night falls for another 70 or 80 years, and I just don't think the society is that discontinuous. I have difficulty believing. I have to put it a slightly different way. Would the amendment have passed in 1866 through 1868 if it had been openly understood to require desegregating the schools?
I guess I think the article currently conflates optimistic originalists and pessimistic originalists together. So I think it's fair to put somebody like Steve Calabrese as an optimistic originalist who thinks the 14th Amendment contains a lot of things that would make America great if they were true. But it seems like a lot of the targets, maybe including Michael and some other people, are more like pessimistic originalists. They see the 14th Amendment having done something, having made a change, a promissory note, that then we fail to live up to for a long period of time, and are maybe only sometimes coming back to. And you know, that's what a lot of people think about Brown. Maybe they're wrong about Brown. Maybe that's the narrative about Brown, is its pessimism, that the amendment promised something that we didn't do it. And I think some of the things you allude to would be even better examples. The 15th Amendment. I think everybody hopefully agrees. The 15th Amendment made a bunch of promises that then for decades the Supreme Court failed to redeem. And it's pretty easy to just see they were just failing to redeem it. Or Section 2 of the 14th Amendment, the promise of reduction of state membership for all the disenfranchisement, which Congress thought about whether to enforce and decided it was too hard and wasn't going to be worth the candle, and they just gave up on. And I guess I think a lot of the scholarship you're criticizing is really a way of looking at that, of saying the 14th Amendment actually did something, made some law, and then afterwards people failed to live up to it.
What my question is whether this optimistic view of originalism helps to explain, at least in the equal protection context, the lack of movement in some opinions with regards to racial inequality, at least in public education. And part of the reason why I'm thinking about that is somewhat of your use of the slaughterhouse cases, which is one of my favorite cases to teach because it's, everything in it is like no longer really good. But one part that always intrigues me is its treatment of the Equal Protection Clause and this idea that the only group that would be protected would be African Americans or descendants of former slaves. And I may be overstating the court's holding there. But then we kind of have some time later, over a century later, Crossan telling us, no, everyone has equal protection under equal protection. And of course, all of this is in the context that we've seen more reverse discrimination litigation when it comes to public education, even though we still have this extreme underrepresentation. So, I sometimes wonder if a lot of that has to do with Brown and the strategic focus on separate rather than equal, and the court's somewhat conclusion that if we integrate, we could get that equality, but of course we never really had the integration. So I don't know if any of this is really making sense, but I wonder if this optimistic view of originalism is also a way to sort of not delve into sort of what some of the core on the ground real issues are with regards to constitutional interpretation, the guaranteeing of rights, and particularly with the Equal Protection Clause, the issue of public education.
Yeah, of course there are originalist analyses that support affirmative action. My concern about the pure form of the new originalism, or original meaning, is that a lot of the argumentation and evidence that Miller presents in Slaughterhouse about the true purpose is ruled out. You're not looking at that. You have to look at the semantic meaning, and it's a little more like a linguistic and dictionary rather than purpose. And there's a constant theme in this literature of ruling out, looking at purpose, which I think produces a lot of the pathologies I talk about in the sequencing argument. To Don, I'll just say I have a great response. and look, W.B. Du Bois said exactly what you express skepticism on, which is that there was apparently a magic period where everything was going great, and then it falls apart. In the legal literature, that's attributed to politics. I'm trying to provide a corrective to that.
So my view on the purpose question is that new originalism is right in theory, but that when you are trying to understand the most likely meaning of text which was designed to do something, the purpose of it is just extraordinarily good evidence of what it meant. Sometimes people completely screw up their enterprises. But generally speaking, if you want to know what somebody's directive means, it's extremely helpful to know why they gave the instruction. As to change, I mean, this, to my mind, it's such a clear example of where they got out ahead of their constituents. And they had their hats, given to them in the election of 1874, and then they just bargained it away. And after the election of 1876, it's over, and they got out ahead of them. But I'm not quite sure. So Stephen is right in a sense that they would have had to do some things that are much more radical in order for the 14th Amendment actually to work. I'm quite persuaded by that. But those things would have been massively unpopular. Even the most radical well, maybe not the most radical, but Republicans who are perfectly happy with the civil rights moves of Reconstruction were not prepared to do away with federalism. And I don't think you shouldn't stop at federalism. How about democracy? When you have large numbers of people who are opposed to what you're doing, you can't be a democratic republic for long. So there are troops in the South for as long as they could stand it, and then it was over. But wasn't it better that they did what they could do? Even though they may very well have realized, and it certainly turned out to be true, that it wasn't going to work, but they did what they could.
Okay, well, thank you, Stephen and Michael.